At its core, a contract is meeting of minds. But what happens if one of those minds is an algorithm? Good morning, distinguished guests, Honorable Vice Chancellor, Dean, Faculty of Law, and our respected faculty members, students, and our online audience. I am Dr. Archana Sehrawat, and on behalf of Center for Commercial Law and Corporate Governance School of Law, IILM University Gurugram, I extend a very warm welcome to everyone for today's roundtable on navigating commercial contracts in the age of artificial intelligence and automation. India's commercial contracting ecosystem is undergoing a structural shift, driven not merely by technological adaptation, but by the convergence of regulatory frameworks, market expansions, and digital infrastructure. Anchored in the enduring principle of Indian contract law, the legal framework is now being tested against a rapidly modernizing business environment, one that prioritizes speed, scalability, and cross-border integration. With India emerging as key participant in global conversations, further underscored by India hosting the Global AI Impact Summit in 2026, ease of doing business reforms backed by expanding digital infrastructure and streamlined compliances. They have significantly accelerated this shift. At this point, the question is no longer about gradual adaptation, but it is whether our existing legal foundations can keep pace with this rapid transformation, or whether a more deliberate recalibration of legal norms is now inevitable. Today's dialogue is enriched by the presence of individuals who engage daily with the evolving realities of commercial law and practice. We are truly honored to host such an eminent panel of speakers. To mark this auspicious beginning of today's program, may I request our Honorable Vice Chancellor, Dean School of Law, Faculty Team, Center for Commercial Laws and Corporate Governance, along with our distinguished guests to come forward for ceremonial lamp lighting. Thank you, everyone. This ceremonial lamp symbolizes the pursuit of knowledge and dispelling of ignorance, values that lie at the very heart of academic inquiry. Before we proceed any further, it is our privilege to felicitate our esteemed speakers with a token of our appreciation for their gracious presence with us today. May I request our Honorable Vice Chancellor, Dean, School of Law, to kindly join us on stage for felicitation ceremony. I would like to invite Mr. Amar Sundaram on the stage. Mr. Sundaram is Senior Vice President Legal, General Counsel, and Chief Compliance Officer at NEC Corporation India Private Limited. With an extensive experience across leading Indian and multinational organizations, including DCM Shriram, Birla, Tata, AT&T, Reliance, Citi, EY, and RBS NetWest Group. May I request Ms. Simran Barar Kapoor to kindly join us on stage? Ms. Kapoor is a distinguished advocate at the Chambers of Simran Barar Kapoor and leading her practice in civil and commercial laws. After graduating from Campus Law Center, University of Delhi, in 2005, she began her illustrious career spanning over 2 decades with Karanjewala and Company. She has led the alternate dispute resolution practice as a partner and is known for her expertise in the commercial litigation and dispute resolution. May I request Mr. Aditya Vikram Jalan to kindly join us on stage. Mr. Jalan is a partner at AZB and Partners, specializing in high-value corporate and transactional advisories. With over 15 years of experience in dispute resolution, he advises on commercial dispute, regulatory investigations, arbitrations, white-collar crime across the sectors including infrastructure, power, and financial services. I request Mr. Rahul Kinra to please join us on the stage. Mr. Kinra is a partner at J. Sagar Associates, specializing in corporate and regulatory advisory. He has significant expertise in the power sector matters, including tariffs, insolvency, sectoral reforms, and has represented clients before major courts and tribunals across India. Joining us next is Ms. Anshum Singh. May I request you to kindly join us on stage? Ms. Singh brings over 19 years of experience and has held key leadership roles, including Vice President, Head of Legal at PRISM, Head of Legal at Fairportal, and senior legal positions at OYO and Zomato. She is an alumna of Nalsar University of Law, Hyderabad. I'm glad to invite Mr. Madhav Khosla to kindly join us on stage. Mr. Khosla is a counsel at Khaitan and Company, specializing in corporate law and complex commercial disputes, particularly of technology clients. His work spans over emerging issues such as AI training, software contracts, deepfakes, data disclosure, and platform regulations. May I now request our Vice Chancellor, Sir, Professor Ravi Kumar, Dr. Ravi Kumar Jain, to kindly deliver the welcome address.
distinguished guests, speakers, esteemed members of the legal fraternity, respected corporate leaders. I see some familiar faces, or faces where I could trace some past connects. Faculty colleagues enthusiastically participating on a Saturday. Dear students, making your time on a Saturday morning. Normally 11 बजे दिन उगता है Saturday को. You are all here. And the participants joining us online, very good morning. It's my privilege to welcome you all to this new beginning. Anything first is always good. It sets the tone, it sets the momentum for right things, and so is this first round table hosted by our Center for Commercial Law and Corporate Governance of School of Law, ILM University. A disclaimer is I have used AI in putting my thoughts for this talk today, and AI is all pervasive. Now it is no more a fancy term. It is part of everybody's personal and professional life, and a lot we do, from selection of which stock to invest, to what to buy, which mobile phone has most advanced features, which is giving you great value for money, to drafting complex contracts. AI is all pervasive. The theme we deliberate upon today, that is navigating commercial contracts in the age of AI and automation. As I said, AI is all pervasive, from drafting speeches like these to complex contracts. This topic is very timely and transformative also, because from here on, we are going to move forward in terms of integrating technology into our work. It cannot be technology and work. It is work with technology, integration of technology with work, or infusion of AI with work. It brings a lot of advantages and also a lot of gaps which your regulatory frameworks or your market dynamics or your clients or your practitioners, there is a lag in adoption of technology. The speed with which technology is moving or evolving, especially AI models, every week there is something new. A couple of weeks ago, Anthropic made an announcement pulling the global market, stock markets down by massive, I would say, erosion of value in trillions of dollars. Day before yesterday, some Chinese AI company announced the stock investment advisory tool. It says it doesn't just get you intelligence from the models and markets, but also conversations that are happening within the AI bots. Now that's interesting. So you are consulting, AI bot is consulting million other AI bots to advise humans where to invest. Now, in this context, it is very, very important, as AI is no longer a peripheral tool in corporate practice. It is drafting contracts, advising for investments, reviewing clauses, conducting due diligence, predicting litigations, whatever risk involved in litigations or litigation risk exposed, and automating compliance frameworks, especially compliance and litigations. These are major pain points for practitioners. What once took weeks of expert eye for detailing AI is able to draft in minutes, scanning through or skimming through millions of pages of contracts and the precedences and stuff like that. The corporate world is already encountering a real challenge, and deliberations like this are essentially going to bring forth how do we prepare ourselves at practice, and also the future generation of how they can equip themselves before they step into the corporate world. In several jurisdictions, AI-powered contract review systems have standardized clauses at scale. That's what AI tells me. Sometimes overlooking nuanced commercial intent. A small deviation in an indemnity clause or limitation of liability provision, replicated across hundreds of contracts, can create systemic exposure, which can be dangerous. Sometimes commercially huge cost may be involved. Who then bears the responsibility? The lawyer who prepared that? Or is the tool which is used? Or the corporation which deployed this technology? Or the technology provider who has created this AI technology for that specific activity? Where the buck stops? Who should be held responsible? Similarly, with the emergence of smart contracts and automated execution systems, performance is triggered by code. Again, as I said, this Chinese investment advisory bot is consulting other bots. It's all codified. Human intelligence is not there. Or whatever is there accumulated is codified. Same is happening in this context also. But what happens when the underlying data is flawed? Because most of the LLMs are borrowing from the past. If the problem statement is futuristic, sometimes it gives you very hallucinated, or the system hallucinates and can give you many things which are otherwise not existing. I mean, recently there was a research paper reviewed, and the analysis given by AI has references to papers which never existed. Right? So it's really dangerous when the contracts or the clauses codified by AI tools, if they are based on data which does not exist or a flawed data, or when the algorithm behaves in ways not fully anticipated by the contracting parties. Our traditional doctrines of consent, mistake, liability were designed around human intention, not machine learning models. Now this transition, or rather transformation, which is a permanent change, how do we react to it? These developments compel us to reflect deeply. And today's roundtable is essentially an opportunity for that. At least start that contemplation, start that debate, start talking about it, and see where do we take it forward. So on this occasion, I thought I'll throw three questions, maybe that may become the basis for today's deliberation. I'm sure all learned practitioners are here, so they'll bring in more multi-dimensional views to the same. Three questions that may set the tone for today's deliberation. The first one, how should the law define accountability on an AI-augmented contracting environment? When decision-making is partially delegated to algorithms, where does legal responsibility ultimately reside? Question one. Question two, how do we preserve human judgment in a world driven by speed and automation? Can efficiency coexist with ethical reflection, contextual understanding, and professional discretion? Third question would be, what must institutions like law firms, corporations, academic institutions, regulators to do to ensure preparedness? Are we equipping our future lawyers and corporate leaders with the technological literacy and ethical grounding necessary for this landscape, or new landscape? In fact, these were the points echoed yesterday in our Greater Noida campus where we had this 13th PRME conference, where we said, can technology and humans, the high tech and high touch, coexist? And in fact, the management challenge is how do you balance high tech versus high touch? And I think law firms, even regulators, are not immune to this. They have to find a balance. These are not theoretical concerns. Basically, these are very, very practical. They sit at the intersection of corporate governance, compliance, risk management, and public trust. And that the public trust is the most important one. Can technology contribute in eroding public trust on the practitioners? ये तो AI कर लेगा, हमको experts की क्या ज़रूरत है? Why should I ask and go to law firms for this? All AI bots can do it for me. Today's roundtable offers an opportunity not merely to analyze these disruptions, but to shape direction. The position paper, I expect, Dr. Bali, that we are going to bring out a position paper out of this deliberation. Emerging from this dialogue can meaningfully contribute to professional practice and policy thinking. I'm confident that with the collective wisdom of experts sitting here, practitioners, corporate counselors, corporate counsels, scholars, and students, we will move beyond apprehension to constructive insight. So on behalf of ILM University, I extend my sincere gratitude to all the experts for sparing their Saturday mornings. I know how precious they are, given the domestic demands that we have over weekends. I wish you a day of rigorous, thoughtful, and forward-looking deliberations. With these words, I formally declare the roundtable open. Thank you. Jai Hind.
Thank you, sir, for setting the tone for the session. We now proceed to our first panel discussion, curated around the theme AI contract interface from drafting to dispute resolution. This session takes a closer look at how legal technological systems are now intersecting to reshape commercial practice. Rather than viewing contracts as static legal instrument, the discussion will engage with how data-centric tools, algorithmic inputs, and the platform-based ecosystem are influencing decision-making at different stages of contractual process. It will also provide reflection on the emerging questions of accountability, interruptive control, and the evolving role of legal professionals within this interface. Dr. Aratrika Deb will be moderator for this session, and the panelists for the session are Ms. Simran Barar Kapoor, Mr. Aditya Vikram Jalan, and Mr. Madhav Khosla. I invite the distinguished panelists to join us on stage and request the moderator to please commence the proceeding.
Good morning, everyone. It's a pleasure to welcome you all today, audience and excellent panelists, to the first panel for the day, the AI contract interface from drafting to dispute resolution. I would not repeat on the importance of AI. I think it has been beautifully covered by our Vice Chancellor, sir. This panel is primarily asking a very fundamental question: whether AI is simply enhancing efficiency within the legal framework that we have, Or are we fundamentally redefining how contractual relationships are understood in today's times? I'm Dr. Ratrika Deb. I welcome the panelists once again. Ms. Kapoor, Advocate, Chambers of Simran Brar Kapoor, Mr. Aditya Vikram Jalan, Partner, AZB & Partners, and Mr. Madhav Khosla, Counsel Khaitan & Co. Thank you all again for being here. Ms. Kapoor, I would like to first start with you. My first question to you is, where in your current practice do you see AI meaningfully intersect? And has it already begun to change the nature of disputes that you see?
Right. Thank you so much for having me here. The one thing that I can contrast and speak about is that I have been a partner in a large law firm until last year, and now have my own practice. So I think the first thing that I would say is it's been very helpful with is, summarizing documents or just giving that first-hand assistance to me as well as my smaller chamber that I run now. So it's been very useful, very helpful. As far as, the research tool is concerned, I would say whether it's Claude or whether it's, Gemini or it's ChatGPT, that's where the flaws come in. But for things like summarizing or creating even worksheets or timesheets or very mechanical stuff is what I feel personally is what I find it more useful for. A list of dates, a first list of dates, which a fresher may be able to do, but sometimes AI is able to create a better first list of dates than even a fresher. A fresher probably gets that 1 year, once he's there in the profession for a year. So it's been a very useful, helpful tool, and I think technology has to be adopted if we need to keep moving with the times. The ones who are not going to adopt it, just like Google search came or computers came, are going to fall back. It's just here, and it's here to stay. So yes.
Thank you so much. A lot to think on that, particularly our students attending today. My next question to Mr. Jalan. So one of the most important things that students do or lawyers do in general is drafting of contracts. So with AI coming in, do you think practitioners are able to preempt or anticipate the kind of disputes at the drafting stage better than what it was without AI's intervention? Has it helped practitioners?
A very good afternoon, everyone, and thank you for having me over. The question, ma'am, that you ask is a very pertinent one, because today AI is changing the way we practice law and, in fact, the way we live. Human nature has been what one can define in 3 I's, which is invent, innovate, and integrate. Innovation has been a part of, the existence of human beings, and today, integrating the new innovations into our day-to-day lives or our practice is what takes us forward. Similarly, it comes to the legal profession and it comes to your question, which is drafting of a contract. The expertise in drafting of a contract between 2 different lawyers is basically to identify what are the risk points, what are the red, yellow, and green risk matrix of a transaction, and to provide for it to the extent possible at the stage of the drafting of the contract itself. In doing so, of course, lawyers use their own experience, market intel, as also what they know about past disputes arising in the same industry or same nature of contracts. Today, how AI has been able to help in that, or will help in that as it learns more and more, is that it is going to apply and employ the learnings that it can achieve from past disputes. At the core, what is AI is able to crunch and digest data much faster than any human being can. Similarly, it is going to be able to digest data from various precedents, from market research, from what is today available in the web or what is fed into that AI tool, and is able to now give an artificial, so be it, but intelligent answer as to what are the risk points. Today there are industries where the same issues keep erupting in contract after contract, transactions after transactions. Be it in India or internationally, these issues which arise primarily out of the transaction and out of the drafting of a contract, they may or may not be able to be avoided, but they can at least be provided for, or at least an informed decision can be taken on them if you actually are able to identify where lies the risk and why lies the risk. To that extent, I believe AI is an exceptionally helpful tool when it comes to drafting of the contract. Does that mean an AI will be able to take up or has taken up the drafting of the contract without human interface or without human interference? Well, I can't speak for the future, but at least as on date, I don't think so. There is a subjective analysis, well, we could call it the brains, you can call it the gut that a human being has, which AI does not. AI is still limited to the coding, AI is still limited to its own bias, because every AI, according to me, has its own bias. This has been tested, there are reports after reports on it. If you put the same command in an AI model prepared in the US versus an AI model prepared in Russia versus one done in China, they will all give responses basis the bias that has been fed in by the coder. In order to filter that out, there is still some time, and I don't know whether that filtration will ever be possible. So while AI is going to be a very important assistive tool, I don't think it is going to take over the work of a human being.
Just following up on what you said, sir, since we are talking about flagging risks at the drafting stage, have you come across any particular risk that we are seeing because of the AI intervention at the drafting stage? Anything the tool has particularly, brought forth?
Every technology brings risk. So does AI, so does use of AI and every individual tool. Primarily, the biggest risk I see of use of AI is laziness. I think the reliance on AI is at very different levels by every individual. Today, if you are entirely relying on the document that AI generates, you are not applying yourself, and you'll be surprised how often people are doing that. There lies the one biggest risk of the use of AI, according to me. Everything else is subjective, everything else depends on what instructions are given, what is the dialogue that you enter into with your AI, what is the data that you feed into AI. And all that can possibly be reduced with the ongoing usage of AI. Because as AI is learning, so are we learning how to use AI. The one thing, according to me, which is non-negotiable and which is the biggest risk is definitely not applying yourself beyond what AI does.
Thank you so much, sir. Again, a very important taker from this is that we are all becoming heavily dependent on artificial intelligence. And particularly students or even us, whether it's assignments or whether contracts that they will eventually work upon. I'll move on to my third question to Mr. Madhav. Do you think AI is pushing contracts to be more standardized? I ask this because I want to understand whether negotiation as an exercise, when two opposite contractual parties are sitting, does that dilute that negotiation exercise if contracts become too standardized?
No, I don't think that's something that you can say necessarily is happening. What we do see is, for example, when you have private equity funds, a Warburg Pincus, a KKR tends to have certain constructs that they insist on across any investment in a sector. So to that extent, everybody has a standard form, any large corporation has a standard form they want to deal with. So we already exist in a world where contracts are standardized. We have extensive tests varying across jurisdictions about what you do when two standard forms collide. What we see, in my experience, happening with AI is that parties are a little bit more informed about where they will push for what risk. Because let's be clear, what is a contract? A contract is an allocation of risk between two commercial parties. So you say, look, this is what I've done in 25 contracts in this sector. You have the data and you make an allocation of risk on that basis. And AI is pointing out those patterns for you. We've got tools which are saying, for this fund, they've made 25 investments in this space over the last 2 years. Where are they willing to budge? Where have we seen a dispute pop up? Where is there a lack of clarity in the clauses? Those pattern identification points are where AI is really useful. That being said, once you have that information, it is still very much a negotiation between two humans, right? So it's a question of, is it a more informed negotiation rather than is it dispensing with negotiation? And I think that's one of the better ways in which we're finding that AI is assisting legal practice, is that are we making better decisions in those spaces? One of the oldest uses of AI in the legal space has been to predict the outcomes in patent cases. It's one of those places where there are really bright line rules. So identification of prior art and then say, how is the court going to apply these rules to this technology? Can you make a prediction? The more bright line rules you have, the clearer it is, the more objective it is, the more helpful AI is. So are you using it to identify patterns, using that to inform how you're going about contract negotiation, how you're going about even making decisions in standardization of your own sort of, standard forms? Those are really to my mind, the best uses we have of it today. So I wouldn't go so far as to say that there is a broad standardization. I would say that sophisticated parties are using it to negotiate more smartly. That being said, I do have one sort of broad pet peeve about standardization and AI. I think a lot of the way that legal AI is marketed is very problematic. You see a lot of these posts saying, this agent is drafting a contract as good as someone from an Amarchand, from a Cravat, Swain and Moore. And it's, it's a very basic contract. And that tells you, associates at Skadden, at Amarchand, at Khaitan, at AZB are not spending a huge amount of time on an NDA. They're not spending a huge amount of time on a simple purchase agreement. They're spending a lot of time on complex commercial contracts, difficult questions, what are the edge cases? The marketing of AI as if, what you need is really simple and AI has taken away a legal function. I think it tells lay people that you don't need lawyers across the board, and it tells you that AI is more reliable than it is. I think that is really problematic. So I think you will get a lot of standard form contracts picked up from AI where business people say that, look, I don't need it, I pulled it out of Claude, I'm sure it's fine. From a disputes lawyer's perspective, I think Aditya and I are really happy about this. It means, the next 10 years are looking good for us. But I think it's, in general, there is a danger to think that information being democratized means that a skill has been taken out of the window. This is very much a skill profession. It is not a knowledge profession in that way, I think.
Thank you so much. Again, following up on what you just said, so you're saying that in negotiation, essentially, we still need human intervention. You need lawyers to negotiate contracts. In future, do you see that getting, AI assisted? Are lawyers going to eventually depend on AI for negotiation strategies, so to speak?
I think we already are. I think that's the point, is that to what extent you're depending on it makes a difference. Are you depending on it to give you the information that you need to make an informed decision? to say this is where I'm willing to budge and this is where I'm not. Yes, to that extent, I think we are using AI to aid decision making. Right? And I think that is very much the right answer. I think everyone agrees that even going down the line, humans in the loop is an essential part of every AI-assisted decision-making process. You're getting a recommendation. The same as, I'm a lawyer, I make a recommendation to my client, you can drop this clause, you can be willing to budge here a little bit. Clients are increasingly getting that from AI, saying that, this is what our past experience tells us, this is a way that I can distill that knowledge. Is that always accurate? I think even where it's objective, yes, you can take it a little bit more, saying 25 cases I've dropped this particular clause, so maybe I can do it.
Okay.
But does it make sense for you in this contract? That's still very much a judgment call that is being made. And I think that's a judgment call that still needs to be made by people.
Thank you so much again for answering that. I'll come to Ms. Simran again. So my question to you is, if hypothetically both parties are relying heavily on AI-assisted drafting, how do you reconstruct mutual intent maybe at a later stage if one of the parties is not able to fully account how a particular clause has come into being? Do you think that kind of situation is going to arise in future? Yeah.
bit more.
So let's say I have used AI heavily while drafting my contract, and of course it has been reviewed by human beings, lawyers, right? And much later, a particular clause, due to lack of human oversight, a particular clause, is being disputed upon, and we come to know that it is AI generated.
Okay.
In that case, how do you deal with that?
To be honest, I don't have an upfront answer for that because I don't think I've encountered something like this. And I'm not sure if we have reached a point, maybe you'll be able to throw better light on it because you said the laws are still being made on this. As to if it's AI generated, are you saying that where the accountability will lie? Is it the lawyer has not reviewed it, so
Yes.
therefore it's
yes.
all on AI?
Yeah.
I'm not sure we are there yet. I think lawyers are still very much involved when there's a contract which goes, and ultimately when the client comes to you. It's, say I've drafted an AI-generated draft, right? I send it to a client. Now the client doesn't know who's drafted it, whether it's AI or it's me, right? But he thinks it's me, naturally.
Yeah.
The buck stops with me, right? Now on the other side, if the similar situation has happened, so at the moment, I would say it's the lawyers who would be held accountable in that sense. And when a dispute arises, but then there has to be a disclaimer right at the start that this draft has been drafted by AI, and I don't see how we are going to reach a point where AI drafted contracts, how the disputes are going to be resolved. I don't think that's covered as yet at all.
Okay.
I mean, I'm not aware, maybe because, my colleagues here who said that
If
they
anyone
were-
else would.
yeah, maybe he would be better equipped to answer that.
Without saying more than I can, I believe when it comes to disputes on contracts and whether there is ad idem, in the real world, what brings ad idem, at least upfront, is the signature at the bottom of the page. Well, it was in the movie Spider-Man that someone had said, with great power comes great responsibility. So if you have the power to sign a contract on behalf of a commercial partner, you are the one. Sorry. You are the one that then has the responsibility for what you have signed. Let us assume a case where a lawyer has advised on a contract and there is a dispute on that contract. The responsibility and the liability still is on the contracting party. It is not on the lawyer. Of course, the contracting party may question the legal advice they've received, but the court is not going to not impose liability upon you just because your lawyer gave you wrong legal advice. I think AI is not going to change that. It is your choice at the end of the day to draft a contract through AI. You are bound by it, period. I don't believe any court holding otherwise.
Thank you. So I think this is another great example of the fact that the law we have today is going to apply to AI across the board, right? So what does the law say about a contract and intent of parties? Once it's written down, it's the black letter that takes primacy. So you look at the language of the contract. You sign the contract, it's exactly what Aditya is saying. You are bound by those terms. So the court is going to be looking at that, not going to be saying, did you get this from AI? Did your lawyers draft it? How good were your lawyers? Yes, you do get cases where, the language isn't clear, courts and tribunals go into looking at intent. Those edge cases, I think, are really where you're going to have a problem. I've done shareholder disputes where the formula for determining consideration is really complicated. You've got witnesses giving differing interpretations of the contract for days on end. Right. How are you going to do that in an AI context when an AI has drafted that contract and no one has a witness that is able to explain it? Those are the sorts of edge cases that you're really looking at. But for the vast majority of cases, where are you really going to have this problem? You're going to have it in lower value contracts, relatively simpler transactions where parties feel comfortable saying, I can take something that is automated and it's not a big deal, I can use this. Okay. So you will have less sophisticated parties, less sophisticated transactions. You will have what's called the long tail, where this is being used much more extensively. Confusion in those sorts of transactions is actually a much bigger problem because it may not be worth somebody's while to litigate it. You have a $100 million contract, there's a breach of it, nobody understands, there's an AI-generated clause that is snuck in somewhere. That is a major problem, but lawyers will be trying to resolve it. Parties will have a serious interest in resolving it. It's a small sale of goods transaction. Is it really worth either small-time merchants' time to be fighting this out in court? No, but that's a much larger concern, is that who are you affecting by irresponsible AI use?
Thank you so much. My last couple of questions would be to, again, all the panelists. First is the accountability question. I think the one that we get most whenever we talk about AI. And how exactly have you, come across the liability issue or the accountability issue for any AI-driven outcome that you've seen within the current legal framework? That said, we know that there's not a lot of laws regulating AI as of now. So if ma'am could...
Yeah, I think my area is more litigation, more than, say drafting of contracts or things like that. I think with the answer to that would be that as far as, I do feel that when a client comes to me for, say, a dispute, where I have to go afresh in a suit or a writ or whatever, here I'm really talking about the interface when say a fresher were to join a firm or whatever. I'm not talking right now about the contract and the dispute that arises later. I'm talking about when my office is creating a fresh pleading, When the client comes to me, I draft that, say I use AI tools, I do whatever, I put in research. At that point, especially from a college student point of view, I'd like to point out that reliance on AI to create that draft, full reliance, would actually be very dangerous, right? So you create a first draft, and like I said, the procedural, mechanical things are okay-ish, and then you look at the paperwork and the documents and you verify it. And the legal research accountability, of course, lies on me when a client comes to me, right? It's not that I can tell him tomorrow, there was a Supreme Court case where the bench has just identified AI-generated case laws cited in the petition. Right. Now, who's accountable for that? It was the advocate. So a word of caution for all students getting out there, because AI is here to stay. You cannot possibly rely on those kind of things because you will be held accountable. Can you imagine the consequences of the client who's had to hear this in court, that you have cases that don't exist in your petition or you're relying on those? And they genuinely don't. I've had 3 cases pop up in one of my cases, in one of my drafting, where when I sent it to my junior to verify, he says these don't exist, or the findings that are there in these cases that ChatGPT is saying, there is no such wording. So there's a huge level of, I think, responsibility that we as advocates will need to have. And I think laws should be made to that effect, where the lawyer is going to take some responsibility to what he's going to churn out to the client, because at the end of the day, he's paying you. So I think that's very essential to know. It's a great tool. It's like having an assistant, but do not rely on it. It's like if I tell my clerk to draft and I put in that draft in the court, it's going to be a disaster. So at the moment, I treat AI like that. So, I mean, I could only answer that aspect of it. Contractually,
Thank you so
So
much.
just two bits on what actually came from Simran. One, a similar case happened with me, as she mentions, where it was not in court, but an intern gave me a work product which was based out of AI, and well, the judgments therein were not real judgments. And I asked that boy to get the system, and I wanted to test something out. So we placed a command on the AI saying, why did you give me these judgments? Because I see that these judgments do not exist. The response that came was very, very interesting. It said, I believe this is what you were looking for, so I gave you these judgments. This is where I was talking about the bias that comes from AI. All AI tools are biased. They are going to do this. So you need to be very, very careful how and how much you use AI. And second, what she mentioned about laws. There's in fact rules that have come out by the Singapore Commercial Courts, if I remember correctly. It's a wing of the Singapore High Court, which is called the Singapore Commercial Courts. They have come out with rules regarding use of AI during matters in Singapore and before the court. And well, they specifically mention that A, you have to declare that you have used AI, and B, the responsibility of usage of AI is on the parties. Therefore, at the end of the day, it is the parties who will suffer or will gain from the use of AI, and therefore, since the benefit lies to the party, any loss or risk can only be associated or identified with that party.
So I think there's actually two parts to the allocation of risk in liability and responsibility question. So I'm, I think, very fortunate about doing India's only two real AI cases at the moment. One's on AI training here in the Delhi High Court, but the other one in Calcutta, and without saying too much, is actually about an implied obligation that an AI platform has about its results. Is there an implied duty to anyone who is mentioned in your results in a certain way? Do you have an obligation to treat people fairly? You know, those sorts of questions are already coming up. So there is that question of responsibility for AI platforms, whether it's for platform output or training, is something that Indian courts are already looking at in a litigation context. I think as a broader trend that's very consistent with how we've seen tech regulation occur in India. We have, you know, our IT Act is of 2000. Courts have been stepping in on search engines, on non-consensual intimate imagery, on child pornography, have been very actively stepping in, whether it's a search engine, a messaging application, domain registrars and IP infringement. And AI is no different. Courts are going to litigate this answer before government frames policy. And in many different ways. So it's not as if AI and liability aren't questions that we're dealing with. We're already dealing with lots of clients who have agentic AI tools, saying, you know, how do I make sure that I limit liability for what my chatbots are saying to customers, for what my sales and procurement teams are using chatbots to say to people they're dealing with? The answers mostly is that these contract law principles exist. Agency will answer that, look, boss, you have deployed it. You are responsible for what you've deployed, exactly to Aditya's point. To Simran's point on what we are responsible for, I don't think this is necessarily that different than what I was told when I started the profession. You can't rely on what's in a commentary. You have to read the judgment for yourself. Somebody has drafted this before does not mean you can use it again. Somebody has put this judgment in their draft. How do you know it's not been overturned, altered since then? You have to check for yourself. This is a profession where you owe a fiduciary obligation to your client. One part of it is the commercial risk, but you absolutely owe a duty of care to your clients. You cannot put it onto AI.
Thank you so much for answering that. My final question to all of you is, what kind of regulation would you like to see? You know, AI has been a buzzword, and that is the reason we are all gathered here today. Given the current practice area that you guys have, what kind of regulation do you foresee? How is it going to change the way we look at contracts today, or even resolution of contractual disputes, so to speak?
So I think I'll just, reinforce the point that, I made earlier. I think the one area is the Bar Council of India, because in general, we all have come from law firms, and we, have high standards of practice, or so we like to believe. The general, drafting or general sense of accountability that a lawyer has is not very high, which is why I think in general the profession sometimes isn't viewed very kindly. So the Bar Council of India, probably when the rules and regulations for AI are made, it's essential that there is some, professional ethic and code to which an advocate should be bound. Because at the end of the day, the stakes, whether they are, say, of 1 lakh rupees or 1 crore, 100, 1,000 crore, the stakes for a client are very high. To a client, his 1 lakh dispute is equivalent to, a builder's 1,000 crore dispute. And it's the advocate that he really relies on. So I think AI rules should regulate how lawyers are going to be using AI, how they're going to be churning out drafts, what they're going to be giving to their clients. And that's just the responsibility that lawyers will need to take. Of course, as far as once it's signed and drafted and signed and contracting parties have gone ahead and given an okay to the lawyer, that's okay. There will be a dispute, and that will always happen. But as far as regulation is concerned, I think as lawyers, we should be bound by some professional code as far as usage of AI is concerned.
I'm also asking in terms of, let's say, do you see procedural laws in the country change because of AI and usage of AI?
Procedural
in the sense,
laws
let's
with
say,
regard to?
Let's say evidentiary standards in a court of law.
That all will evolve. It will. Like WhatsApp has become acceptable today, service by, WhatsApp, or emails have become acceptable, which they weren't before the amendment. All those things will definitely come in, and I think that policy, doesn't exist as of today.
Yes.
Our Evidence Act does not today incorporate that. I think the only country, maybe Singapore is what you said, and I think the EU has drafted an Artificial Intelligence Act, which they are also slowly phasing in. And what I read was that there are 5 categories that they have made. So maybe the Indian government is going to look at them for, drafting their own rules and regulations. The categories are that there is some AI which is going to be banned, which is banned. I mean, this is the EU rules. Then there is a lesser and lesser and lesser. So 5 such categories. Certain things are so sort of, against the rule of law, against justice, etc., that they've said that you cannot use AI in those things.
Correct.
They have prohibited it, not regulating it.
Okay.
And the rest of the 4 categories are regulated. So regulation comes in with what is permissible, then whatever. So I think those will evolve, your procedural rules.
Okay, so we've been talking about AI in legal context, but when it comes to regulation, I believe there are 3 buckets that we need to look at. The first bucket is regulating the use of AI in life, business, etc. It is very important that we know the use of AI is not limited to law.
Right.
So when the government is going to regulate AI, it is looking at a broader scanner. It is looking at the disruption, difficulty, and benefit that a common man in his day-to-day life faces by use of AI. So that is one level of regulation that the country must have, which is not limited to any particular industry or any particular practice. The second, as Simran very rightly points out, is every industry, every practice, say Bar Council for lawyers, will come out with regulations for the use or not use of AI in that particular industry or practice or profession. Let's talk about chartered accountants or auditors. What stops them from using AI to prepare your entire P&L and balance sheet? So there, for the ICAI or the NAFRA to look at the use of AI is another aspect. Similar for lawyers, for doctors. Well, self-medication through Google is anyways famous. Yeah. So AI is only going to increase multifold that problem. So every practice is going to then come up with more nuanced regulations. But I believe the most important regulation is, and especially for, the college students sitting here, is self-regulation. I think there is a very, very important aspect of self-regulation or self-discipline on use of technology as a whole. AI is no different. Every individual should take a call, should sit back and think, what, how much, and where can I and should I be using AI? Well, use of calculators have made us forget how to add, subtract, and multiply. Use of saving numbers on mobile phones have, made us redundant on remembering phone numbers. Use of artificial intelligence is going to impact our real intelligence. And therefore, I believe the most important regulation is going to be self-regulation or self-discipline on the use of AI.
Thanks. I think the interesting thing about India is that what we sometimes miss is that there is already a little bit of AI regulation. But it is very much horses for courses. We have SEBI has introduced certain regulations about where and when you can use AI. You have the Indian medical regulators introduced it. That's fairly broad, says, doctors, ultimately a human has to make the decision on treatment. I think that is the right approach, that you will want different regulation in different sectors. You will, for example, want, at a power plant, say that, I want as much AI intervention as possible because it has the effect of net-net increasing the safety in the facility. So it is very much a sector-by-sector approach, I think, to AI. In terms of regulation, I think New York is taking an interesting approach to this. We were discussing this. They are saying that if you have a licensed profession, a layperson on the street can't give you legal advice, can't give you accounting advice, can't give you medical advice, then an AI chatbot equally should not be able to do any of those things. I think that is broadly the right answer. If something is important enough to an individual's life, has an impact on them, you have a fiduciary obligation to them. It is fair that you don't freely dispense that through a chatbot. The question is not really of gatekeeping. It's a question of, are we making sure that people are protected against adverse consequences that they don't know will occur? That being said, all of that being said, I'm a little wary of doomsaying. These saying, be careful about AI is something that we're all saying it's true. That being said, people used to say the same thing about books. You just say what will happen to human memory because book binding, you can always go and pick it out of a library. This sort of chat has been happening for 2,000 years. People have found a way to use technology safely, effectively, in a way that pulls us all forward. I think that's really the focus, is that you can't be exactly like the way you can't be with a commentary. It's written in Mullah, therefore it must be true. Like half of those citations are to cases that, half the time have been overruled. What are you looking at? Is it meeting your purposes? And particularly for the sort of the students sitting in this room, AI makes a lot of things simplistic rather than simple. You will lose nuance. You will lose the correctness of the answer in putting it in a way that the layperson can understand. It is essential that you know your subject in order to be able to use these tools correctly. So to Aditya's point on self-regulation, it's also, I would add self-reliance to that.
Right. Thank you so much. With that, we are coming to the closing of this panel. Are there any closing remarks for the panelists? Something I couldn't manage to cover in the questions that you would want to tell the students, and then we'll take some questions from the students. Anything?
I think Simran's already mentioned it, but AI is an idea whose time has come. There are going to be two kinds of lawyers, those who know AI and those who need to know AI. So everyone in the room, it's a necessary skill set going forward.
Great. Do we have any questions from the audience? I see Ashwet. Yes.
So my view is that high value work and high complexity work will typically tend to be safer than the long tail, because you are incentivized to have, a human intervention there as well. So the amount, you may spend less time debating those clauses. You may spend less time, it may all be fighting over a neutral AI generated clause that has been put together, and then, both sides give their markups. But you still will be incentivized to have a human in the loop because of the value and the complexity of a particular contract. My concerns are more about, this is so simple, let's just get it done. This is, it chota sa contract hai, let's just close it out. Those are the places I am more concerned, because the more complicated it is, the higher value it is, the more someone will say, I know it's AI generated, but take a look and really take a look at it.
Okay. Next, anybody else? Yes, it's Madiha. Yes.
As we discussed about the current standing and the stance of AI, considering the increase in technology in the next 10 years, AI is definitely going to get advanced. And lawyers could also be replaced with how people would just rather go to the AI and search some legal query. So what could be something that the lawyers could still hold their value and be, because it's a profession, it's a legal profession, and algorithms can do nothing about it. So how can we deal with this situation?
Good question. Actually, no answer to that one. But I think I can speak for now. I thought about this question while coming here. That how are we going to remain relevant, right? I think the grunt work, so the grunt work or the mechanical work or maybe, those kind of things, even if it gets taken away, I'll look at it this way right now. I love it that it leaves me more time to do research and reading. I don't know tomorrow even that would develop, because it's developing so fast that even the case law research and all of that, it's probably going to get there. Let's not think it's not. Today it's getting it wrong, but it will, because it's already. So according to me, there will be a sense of human judgment, a value attached to human judgment. It may, this is my sense that for a few years, that's going to stay till even that part goes away. And then as far as even, just to add to your question, are we also going to have faceless adjudication of cases? Are judges going to go away? I think in income tax, there is some faceless adjudication already that has begun, even in India. So these are questions no one can answer. Tomorrow judges can be redundant, lawyers can be redundant, but your knowledge and your analysis of a situation till AI gets there, I think focus on that. Use AI to do your grunt work, to do your work which you would give to a paralegal, and the rest, we just pray to God that it doesn't go.
Very briefly, opposable thumbs. If humans could grow this thumb just to be able to hold things and be, stronger than the rest of the animal kingdom, we'll figure out a way to have an opposable thumb to survive AI.
I think Simran's point is actually where I resonate with this the most. I spent the first 2 months as a qualified lawyer separating different kinds of invoices in a construction contract. I think all of you are very lucky that you're not going to be spending as much time doing that sort of thing. Yeah, so I think in some ways you can look forward to a more satisfying, stimulating legal career. You will spend more time on the hard problems. I think is great. The other part is I think we can also be confident that lawyers will always regulate for themselves. We will always make sure that, and this is something that's happening in a lot of parts of the world. You're saying humans in the loop as a mandatory condition. There are jurisdictions which are saying, the EU, for example, that you cannot involve AI beyond a point in legal practice. So to that extent, there is, are some safeguards that you are looking at, and I think there should be. But ultimately, there are parts of this profession that will work are a little bit more insulated for a little bit longer. I think litigation, and everyone on this panel, I think will agree, moves a little bit more slowly. So you will find, judges are older than the lawyers typically who are appearing before them. You will find that they are a little slower to adapt to whatever technology is there. You will find it is therefore less prevalent in litigation than in corporate practice. Slower to adopt, slower to come into official channels, That being said, there are other parts of the world that are moving much faster with this. There is the American Arbitration Association has what's called an AI arbitrator. So for construction disputes, they run a first tranche of the documents only proceeding through the algorithm, and those findings are presented to the human arbitrator. So there is really anyone's guess where this goes over the next 10 years. I think it's much easier to plan for the next 2.
We'll take one last question from Kashish. I think she'd raised her hand.
So I think India's already taken a position, right? We're taking a more balanced, horses for courses, sector-specific, issue-specific take on it, right? The Indian government, last year we had the AI, a report, interministerial committee report come out, which said, in the short term, we're looking at self-regulation. In the medium term, we're looking at amending key statutes, the Copyright Act, the Information Technology Act. SEBI will make, and then letting sector-specific regulators see what they think needs to happen in each sector. We've already seen SEBI take a lead on this. We've seen the Indian medical regulator take a lead on this. And then in the longer term, see where we think a sort of integrated AI Act can come in. So I think India is taking what I think fairly is being described as a balanced approach. The US is, I think very clear in what it's doing in its, things are laissez-faire, let the market figure it out. But even there are a lot of questions on AI that courts are having to deal with because the courts are having to apply existing legal principles to new problems. You've seen there are chatbots which have, people having conversations with them. There's a mentally ill child having a conversation with an AI chatbot, has been convinced, thinks that it's encouraging him to take his own life, takes his own life. The parents have sued the AI bot under tort principles. You've seen there are several tort cases against AI bots right now. There's the AI and training issue. There's the AI and copyright and output claims. All of those courts are deciding both outside of India and in India. So to that extent, I don't think legislation is the only place that the regulation is going to come from. And I think that's been very true of the technology space more broadly.
All right. I think with that, we come to a close. And thank you so much once again. The panelists have given us a lot to think upon, particularly the students, since we mostly have our pre-final, final year, and post-graduation students with us today. Responsibility in the context of AI usage, particularly if you are going to be a lawyer. Thank you once again, sir.
Thank you.
And ma'am.
Thank you, panelists, for your valuable insights regarding the impact of AI on contractual architecture. Your analysis has highlighted the significant developments in how technology is shaping legal frameworks, risk allocation, and the formulation of commercial agreements. The discussion emphasized both opportunities and complexities that arise for practitioners and policymakers as regulatory approaches become increasingly adaptive. We appreciate the expertise provided, which will assist in navigating the changing issues of accountability and liability within AI-driven contracting. Moving further, our second panel on governing AI in commercial contracts, liabilities, risks, and regulatory futures. The session focuses on shifting priorities from efficiency to accountability as AI becomes central to commercial contracting. This session will be addressed assigning responsibility for AI-influenced outcomes, managing risks like error or bias through contractual provisions such as indemnities, audit rights, and evaluating if current regulatory frameworks are sufficient to include transparency, oversight, and ethical concerns to issue fairness, integrity into contractual frameworks. Except for legal and policy fields, we will discuss the practical strategy to balance accountability within innovation in AI-driven contracts. The moderator for the session is Dr. Astha Mehta, and the panelists are Mr. Amar Sundaram, Ms. Anshum Singh, Mr. Rahul Kinra. I welcome the distinguished panelists to please take their seats on the stage and moderator to begin the session.
So good afternoon, everyone. I'm Dr. Astha, Associate Professor at the School of Law. It is a privilege to moderate this panel on governing AI in commercial contracts, liability, risk, and regulatory futures. You know how contracts were built for certainty, and the AI is built on probability. So today we are going to discuss how the two worlds are going to merge together. So this raises a fundamental legal tension. How do we reconcile the certainty that law demands with the uncertainty that AI is bringing in? From questions of liability and risk allocation to regulatory fragmentation and enforcement challenges, the legal system is being quietly but profoundly reshaped. To unpack these complexities, we have with us the exceptional panel, Mr. Amar Sundaram, Senior VP Legal, General Counsel and Chief Compliance Officer at NEC Corporation India Private Limited. Ms. Anshum Singh, Partner at Wadhwa Law Offices. Mr. Rahul Kinra, Partner as JSA Advocates and Solicitors. Thank you for all taking out time amidst your busy schedule and being here with us. Let me begin by setting the tone. This is not just about whether AI fits into the existing legal frameworks, but whether those frameworks themselves need to evolve. So beginning with the discussion, sir, if I may begin with you, Amar, sir. Where do you currently see the greatest legal uncertainty when AI systems are used in commercial contracting?
Thank you, Professor Astha. Let me give an open the discussion deliberation, giving a bigger picture about AI. I mean, that's the buzzword, and we have all been talking about AI. What is now happening, and this is a reality, let's not stay in some fool's paradise that AI is not going to come and it's not going to disrupt the way we think, the way we live, the way the legal profession is progressing. AI is increasingly being used across all sectors of the industries. All corporate houses are now integrating AI technologies into their business. And why are they doing it? They are seeing the value out of it. And when they see the integration of technologies into their business, they see that their productivity has increased. I'll just give you one data point. EY came out with a report in September 2025, and they tried to analyze the productivity of the uses of generative AI. They analyzed 10,000 risks across industries, and these were the industries which contributed to the India's GDP. And when they analyzed these 10,000 activities, they said that 24% of these activities can be fully automated. Then they said that 42% of these activities can be automated to the extent that 8 to 10 hours of your work on a weekly basis for corporate workforce can drastically get reduced. And then they tried to interlink this data point with the productivity, and they said that when we analyze this and link it with the productivity, 2.61% there is a productivity increase in the organized sectors, and 2.8% is the increase in the unorganized sectors. So what is that we are talking about? We are saying that organizations are integrating artificial intelligence technologies into their core business. They are seeing a value. They are seeing that the productivity is increasing. So therefore, technology is everywhere. It's just increasing. Why should legal be isolated? And therefore, it is also into the legal field, right? Can you just repeat the question once again?
So
that I
basically, where do you currently see the greatest legal uncertainty where, the AI systems are being used in commercial contracting?
Correct. So now, while we are talking about AI, we are talking about the technologies, what is not clear is that where it is leading us to. Everybody is integrating, everybody is using artificial intelligence. Where is it leading us into? Where is the accountability? Who is to be held responsible? Who should I sue? So supposing we are talking about the uses of technology in a medical field, or we are talking about artificial intelligence in a car manufacturing. Where should the buck stop? So there are a lot of uncertainties which is around in terms of the liability, in terms of the accountabilities. And as we progress, these deliberations progress, we will talk some of the issues that has come up with the EUI, AI Act, the Japan guidelines, the Singapore guidelines. But there are issues around where there is a lot of uncertainty. I'll give you just one example. There is a huge dispute which is going on in Delhi High Court on the uses of copyrighted materials. So a lot of these large language modules, the generative artificial intelligence, they use a lot of these copyrighted materials. So there is a dispute which is ongoing between Indian media and OpenAI, where the OpenAI is being challenged, and the Indian media house is saying that, look, you are using my copyrighted materials to train your AI models. And therefore, ultimately, they are becoming my competitors. So should I not be compensated? And that's a huge debate which is pending before the Delhi High Court. In 2023, New York Times had already sued Microsoft and OpenAI in US on the same issue, saying that my copyrighted materials are being used to train your AI agents. Should I not be compensated? So there are a lot of uncertainties which is still there in the market. My sense is that as we evolve, as the time progresses, these issues will find a solution to it.
Thank you, sir. The facts that you mentioned were really interesting, that, there is a lot of work that can be delegated to AI, and also the issues which are pending before the court, so much of copyrighted material being available on the AI tools. So building further on that, I have the next question for Ms. Anshum. When AI tools are integrated into contract lifestyle management, our decision making, how should liability be conceptualized, and do we continue with the basically traditional fault-based frameworks, or is it time to think about liability itself?
See, thank you. That's a good question, and thank you for having me over. I think the traditional ways of viewing liability, they don't go away, right? I think we have to understand, and there's a general consensus here and in the industry, that AI is a tool at the moment, a tool that you're using. It's not, it's not dictating or governing the way documents or the liabilities are crafted, right? So I think the traditional ways of looking at liability or ring fencing your risk, that remains the way it is. Yes, it evolves with, like it does ordinarily, with a different commercial arrangement that you would be entering into. Now, when you come, and I think Simran also addressed this when she was talking earlier, that when it comes to a professional and a client coming to a professional, that liability is with that professional, right? Because I'm a service provider, at the end of the day, I'm rendering advice, right? And then when it comes to adopting those tools internally within my organization, I have to have the right guardrails because there are copyright issues. There is the issue of using personal and maybe sensitive data as well to train those modules, or confidential information for that matter as well, right, to train these models. So I think when it comes to using tools, we have to be able to ascertain where that liability lies, and that jurisprudence will probably evolve as well with time. When it comes to commercial contracting, I think the traditional ways of viewing liability, that doesn't change. And we should retain in mind that this is still a tool that works for our benefit, and the way we shape our prompts, the way we shape our questions, and the way we analyze the overall outcome. Because that trained lens, that trained eye, that has a very significant role to play at this point in time.
So would something like strict liability or enterprise liability make more sense here?
Well, I think enterprise liability depends on the tool that you're using, right? I think it'll have to be seen how it plays out, to my mind, right? Of course, I would want the tool to be liable, but then I have to exercise that judgment as to how I'm using that tool, right? By just saying liability is a very later consequence of your actions, essentially. If my actions have been awry, or if I've been led astray and I've not exercised judgment, then just coming to the conversation of liability and saying the tool is at fault, actually, that's a very shallow way of considering, approaching this, I feel.
Just to add to what she said, I'll give you an example. So there is an automatic car, right? The car is a driverless car. It's driven on the road, and the car meets with an accident and somebody dies. Now, it's an open question. I mean, in Indian scenario, under the Motor Vehicle Act, who should be held accountable? Should the car manufacturer be held accountable? Should the software developer be held accountable? Or should the car owner be held accountable? So these are the questions which we have not reached to that level today. Somebody who is developing an artificial intelligence should be made accountable. Today, probably the world is seeing that do not curb innovation. Because if you curb innovation by putting too much liabilities around it, probably the technological advancement may get curbed. And therefore, the focus from the global point of view is innovation with a lot of responsibility. They are saying responsible use of AI, which is the core thing.
And just to add to that, it could very well be the person riding in that car, because it's a rider beware situation. You chose to get into a car which is a driverless car. You understand the risks. It's only when they materialize that then you start to see the consequences of those risks. Knowing and realizing there's a journey over there.
That's a really interesting take. Thank you so much, sir and ma'am. So moving on to Mr. Kinra, my question to you is, are parties today meaningfully negotiating AI-related risks, or are these risks still being absorbed implicitly without clear contractual articulation?
So to answer to this, that AI is a change. We started from books to typewriters, to computers, then laptops, then iPads, and then for which the software is also changing. So to answer to this, we start with the fact that the software as a service model, which started, is now changing. The rights and liabilities are also different because as a software, it was deployed and it was working on the data provided by humans. Today, data is being fetched by that AI model through various sources. So here, negotiations are taking place. There are risks that are involved in it, but the risk allocation is still a gray area, considering the debate of IP access, the copyright case which Sir mentioned and Madhav was stating about open AI versus the news agencies. Yeah. So secondly, the data that is being used for AI to learn for a particular vendor, can it be used for a different party because that AI has now been trained, reached to a certain level? Those risks have to be hedged in the contractual negotiations. So people are learning from their experiences, from something that has gone bad as a bad contract. So it's a business risk. People are involving the trained software professionals to help them, because it's not just a lawyer or a person who's deploying the AI who would know everything. So it is a process which is evolving to answer this.
So I think we are still at a nascent stage where, we would be able to give clear answers only after 5 to 10 years. That also may be.
So for instance, I would just give you a basic example. I work from I work for an industry which is into electricity. My friend Aditya and I work for same clients. So there are risks that you can hedge. A contract such as a power purchase agreement, from my industry perspective is what I would say. There are changes that happen over a period of time. Technology is changing. So the rules, the clauses such as change in law clauses, which never existed in the previous agreements, have come in. We've learned from our mistakes that, for instance, there's a force majeure issue. So we've learned from our mistakes. That was then settled in 2017-18, change in law as a perspective, and what a regulator could do in it. The Supreme Court laid down guidelines. When there are regulatory gaps, the regulator can come in. So we are learning from our mistakes.
So moving on to Amar sir. So do you see standard form contracts evolving to include AI-specific clauses, or will this remain a highly negotiated sector-specific issue?
So today there is a need for sector-specific clauses, not something which is very standardized today. So for example, some of the sectors like the hospitality sectors, the financial sectors, the BFSI sectors, the hospital sectors, these are the sectors where we see a lot of use of data and technologies, and therefore these are the sectors where there is a need to have clauses which is very, very specific to the uses of technologies, including the artificial intelligence. Probably today we have not reached to a stage where we need to have a very standard kind of an artificial intelligence clause. We do have a very standard, in my organization, in all the contracts, we have built in a very standard data protection clauses. So how do you protect the data? So we have tried to build in a very standard clause in all our contracts. Wherever there is a agency or a vendor involved who deals a lot on the data, we have a separate addendum as a data protection agreement, because the liability is so huge, Today, probably we have not reached to a stage where there is a need to have a standardized artificial intelligence clause. But having said that, most of my co-panelists are from the law firm domain. Let me also tell them that as general counsel, as in-house counsels, in many of my engagement letters, and not only us, but many organizations in India and abroad, they are now putting in a clause asking the law firms to make a declaration that are you using artificial intelligence? And if they are using, the billing rates comes down, So that's another standard clause we use for all our law firm engagement.
So,
you know.
to add to that, so our firm has an AI policy, starting from an intern working with us to a partner, to a senior partner. We have set out the guidelines and the parameters for which you can use AI.
Correct.
You can't go beyond it. So that's a violation of a code that our firm has. So we are also looking at it.
So that's really interesting. So let me bring in another layer. So I have a question for Ms. Singh. How do data protection and privacy frameworks, they intersect with contractual obligations, particularly where AI relies on larger volumes of sensitive data?
So I think that's also the judgment we were just talking about at the Delhi High Court, right? AI depends on data, and data is, so it's at the core of, data is at the core of AI. And then, of course, there's the larger question of privacy. And I think those guardrails have to be implemented to ensure that when you're training your models internally or whether you're using it externally, what is the nature of data that you're using, right? So that hygiene, and I think that's what Rahul's saying that the firm's trying to do, right? To create that hygiene, a code of conduct or a policy to make sure that we're not just applying it blindly, so to say. So obviously, data is at the core of this. You have to exercise judgment.
Thank you so much.
Just in the previous question, you asked about the risk associated with the artificial intelligence. And when you talk about the data, so let me give you just one example. You use data, and especially these large language modules data, volumes of data, to train your AI model. Right? Now just imagine if these data are poisoned data, then the very foundation of your AI agent goes away. So the output that you will get, imagine the kind of quality that you will get, and apply this in a very sensitive sectors like a hospital sectors, where there is a lot of AI robotics are being used for treating some very serious diseases. And if the foundation of that AI agent or AI model is poisoned because of the input of a poisonous data, right? The whole output gets impacted big way.
And I think that's where we were earlier talking about AI bias as well, right? You see that come out. You see AI hallucinate. You see AI take things very casually. I know I have, in my in-house stint, relied on AI to draft certain addendums maybe, because that's the fastest way of getting something done. It'll get the cross-referencing right, and it has a very nonchalant, casual attitude. Oh, I got this wrong. As lawyers, we hold people, accountability, and that's something that I haven't seen so far. And you could, we're in a very politically tumultuous world at the moment. You have the extreme left wings and the extreme right wings. You have information being fed into these systems. Who's using it for what, right? So there's a lot of accountability, the kind of data sets, like Sir said, that are fed to train these models. It's just accountability. That's the...
And if you recall, Professor Astha, just few months back, there was a big news item that there is a difference between the iPhones and the Android phones when you are using Uber or Ola, right? So if you are using through iPhone, the charges are much higher as compared to when you are using through the Android phones, the charges are less. Now that is where the element of biasness comes up. What you feed, and there was a big rumor and big news item,
So we as professors also, we keep telling our students to exercise caution while using AI. They should know where to use and how to use. So since we keep getting so many assignments from them, that's the thing we keep repeating.
Sorry, Astha, I'll just digress a bit. I have 3 very young kids. So my mind always goes to what will the world look like for them, right? And this is digressing a bit. But I think the core values of what they teach you in school, right? Traditionally, schools will teach you how to do cursive writing. And that cursive writing is to form that connection, that neural connection, the neural pathways, right? There is no substitute for being a good orator. There is no substitute for being able to articulate. And I think all of that then translates into, as lawyers for us, when we write. You know, you're able to express your thoughts, you're able to articulate better. I think all of that is obviously threatened a bit with AI, because you're not applying yourself, you're not thinking about, for students especially, I think that core skill set has to be developed by them before they move on to the next step of, let me just get this done faster, because essentially what we're all using AI for is to just get it done faster, nothing else. We all have that training, and that's where all the students need to focus on to create that skill set. Yes, get it done faster, but you can't substitute one for the other.
No, that brings a very interesting dimension even from the academician point of view. Today, many students use Gen AI and artificial intelligence to submit their projects, to submit their answers. And therefore, two things will be required from the faculty side. Not only that, you need to have so much of an expertise to assess that this is an AI-generated material, but also that you use a counter AI to understand that this is an AI-generated. So, you know, a lot of discussions have been happening around the negative use of AI, but there are organizations who are using AI to counter the wrongful uses of AI. And I'll give you a common example that we all face. Airtel is using artificial intelligence to prop up that this is a spam call. Now that's an AI. That is where the positive side of AI uses is witnessed.
So definitely it has both positives and negatives, and it's about how we as humans who are using that tool need to assess. So moving back to our discussion, Mr. Kindra, I have a question for you. In cross-border contracts, how do we deal with regulatory fragmentation where jurisdictions impose different standards of AI accountability?
So, I will not say AI is a different, it's a tool, right? Look at it from the perspective of different standards for different medications, different standards for food, the different standards, for instance, India, if you look at it from various states who banned alcohol. AI is so it's not something that the cross-border issue will have to be, you know, it can't be resolved. It has to be harmonized. Treaties will have to be signed amongst the countries. There have to be, for every sector, every aspect, we need to have rules and regulations which are standardized, so that one can bring in more legislations to match that standard. And even for AI also, it's the same. Because we've as a country, for various purposes, have incorporated treaties, COP27. So we have done that. So for AI also, once those legislations are in place, they will have to be harmonized. So there is nothing new about it. It's like a sector that is developing. For instance, Ozempic is something which is in news. So it was costing 4,000 and the patent is over. People are bringing it up for 300, 400. But who's regulating it? It's again a cross-border thing. So we'll have to look at it once it grows.
Thank you so much. So I just have a general question for the panel, anyone who would like to answer. Are our courts and arbitral institutions currently equipped to handle technologically complex AI disputes, or do we need some institutional innovation for it?
So, of course, we all will have our views. See, my view is that today the judges are not trained and up to the speed, especially the pace at which technology is changing. Technology is changing at alarming speed and pace. The judges are not aligned to this change. Do they need to change? The answer is a big yes. But having said that, there are certain segments where we see that even the courts are encouraging the use of AI. So recently the Supreme Court said that the registry should use AI for listing of the cases, and the bench allocation.
This month itself.
Yeah, so they said that for bench allocation and the listing of the cases, please use AI.
They made it mandatory. It's
Yeah,
part of a circular which
correct.
says that you have to follow.
Correct.
AI has been integrated
Correct.
for listing purposes.
Correct. And the whole objective was to eradicate the alleged corruption into the system, So therefore, the courts are also taking cognizance of it. We also heard about the Punjab and Haryana High Court judgment where one of the judges used Gen AI to understand the bail, how bail is granted in a particular kind of an offense across the globe. So the larger issue is that, dependency is a wrong word. When we talk about AI and we say that should be a dependency, that's a wrong word. Usage of AI as an aid, as a facility to facilitate your complex situation is always there. And to that extent, it's absolutely, the courts are also open to use of AI and technology so long it is helping the disposal of the cases or the giving of the justice. But what is alarming and where the courts, not only in India but across the globe, is concerned about is that there is no review of the AI-generated materials. And Chief Justice Suryakant, recent three-judge bench, they said mercy versus mankind. That was one of the case law which was quoted, and Justice Nagaratta was just furious. And she said that this amounts to professional misconduct by a lawyer. And they were quoting judgments which did not exist. And this is not only in India. UK, I was reading UK in June, they came out with the National Qatar Bank case where 45 judgments were quoted, out of which 18 were absolutely fake. So this is a phenomena which is happening across the globe, and this is where some kind of a benchmarking and guidelines is important.
Thank you so much.
So I have a personal use case. Again, in one of my in-house stints, we were responding to a notice, and somebody decided to rely on ChatGPT to draft a response, and then, of course, subsequently send it across as well. Promptly, a few weeks later, we get a response to say this legislation doesn't exist. So it's case laws, it's legislations, So I think, yes, the jurisprudence will evolve. The judges, of course, all of us need to do more. Lawyers, judges, can't just put it on the judges, but all of us need to do more. And of course, the legislations will also, we are already seeing sectorally things being done differently. We've seen, synthetically generated information, the IT Act saying that you have to put watermark it or have the audio content. If it's an audio generated information, then you need to have a prefixed audio content to say that it's artificially generated. So we see all of that happening. I think given that it's a journey that's just started, we have a few years to see how it plays out.
State the question again. I would want to pick it up from there.
So basically, I just
You said, are we ready
I
for...
was asking the courts and the arbitral institutions whether they are ready or we need to have a specific institution,
Okay. So my answer is, are we ready? What are judges? There are people who've been part of the bar and have reached, or they've come from judiciary. So are we ready? We're still discussing the pros and cons and how this is developing. So you can't expect them to be ready. So it's a development process, and it's more about responsibility and accountability. For instance, if you used AI tool for research and drafting, you may use it. Although I'm slightly against it, but you may use it because you can't run away from it. But after that, you need to read all the facts. You also need to look at the case laws and the laws that have been cited. You need to read them. The human intelligence has to be there. You need to interpret them. That is why what we are paid for. we can't just rely upon a model that has given us an output. It's like Google giving us some research. Unless we look at it, read it, analyze it, it will be something which can come and bite us, what she said. So it is our involvement that has to be there as of now, but how things change is something we'll have to look at.
So certainly human intelligence cannot be replaced, and eventually, I mean, ChatGPT or any of AI tools have been developed by humans only. So we cannot doubt our intelligence and competence.
I think Aditya mentioned the gut. The gut feeling is something that, when you argue a case, because I'm a litigant, we have several grounds that we take. But on the date of hearing, it's the gut feeling that we need to emphasize, or we need to tell our senior, or when we are arguing that you need to emphasize on this point, this may make a dent in our favor. It's the gut feeling. For AI, I think it's some time for it to reach, probably.
We are still at a stage where, we are using AI for just the basics.
Correct.
Eventually, it's our skills, which matter. So I would request our panelists for their concluding remarks if they feel that something has not been covered during the session, something that would be beneficial for our students.
AI is definitely a big disruptor, there is no doubt. It's going to impact each one of us. It's going to impact each and every sector. It's not just the legal sector. It's impacting. It's already impacting. In terms of your placement, in terms of your job opportunities, things, by the time you graduate, things will not be the same as it appears today. That's the nature of the technology. It's changing at an alarming speed. As we move forward, the element of precision and the element of accuracy that these technologies are throwing is much, much higher. I remember the phishing emails that we used to get 1 year back and the kind of phishing emails that I get now. There is a complete difference. Today, these phishing emails look absolutely similar to a natural email that a person receives. There are no grammar mistakes, the contexts are given, the background is given, and therefore there is a assumption that this is coming from the right source. Precision, accuracy is going to improve day by day, right? Does your job gets impacted? Does your probability of getting a job in the market gets impacted? The answer is yes, it does get impacted. Let's be realistic. Does it completely eliminate your chance of getting employment? The answer is a big no. Today, what is happening in many of the corporates is that not only the hardcore lawyers, people are now learning new technologies, the new areas where it is developing. In-house counsels are now, in-house teams are now hiring data scientists. They are hiring data analysts with an interface with the law. Right? When I deal with my lawyers, my junior lawyers, I need to understand and I read and I want to see that how technical bent of mind that person has. So definitely that old era is gone. You need to be aligned with the changing circumstances and be technical pro. I mean, you should be more inclined towards the technical aspect. That's how the system is growing. That's how the world is growing. It doesn't take away your entire employability options. There are newer areas which are coming up and developing big time. And these are the new areas where the law will have a big say next 4 to 5 years. Cybercrime is one. Data is another. Copyright is third. There are new areas which will throw new phase of litigation, new phase of work. You need to gradually move towards that and focus on those areas rather than those traditional areas. Traditional form of litigation will remain, but it will remain in a different form and shape. Right?
Thank you, sir.
So yeah, I think Sir's articulated it very well. My 2 bits for students essentially is there's no shortcut to reading and learning. I think when you have depth, that benefits you always, right? So don't shy away from creating that depth. Second is, none of us like to be challenged. This is just something that's challenging you. You have to find a way to work with it, work it to your advantage, and to benefit from it, right? I think that's just my 2.
Thank you.
I think we need to adapt. It's a change. So technology changes, areas of law changes, but the principles of law remain the same. Constitution remains the same. Natural justice remains the same. So you have to be clear with concepts and basics of law, firstly. And what Anshum said, there is no way of running away from reading. You need to read, understand, analyze, only then you'll be able to come up with solutions. Without that, AI also has to be trained. So you are also students, you have to train yourself to adapt to the changing circumstances. That's all.
So thank you so much to all the panelists for their concluding remarks. So I think any new change is going to bring a lot of discomfort. It's for us to get comfortable with it and stay updated. So I think that's the same thing with technology and AI tools, that we stay relevant, we stay updated, and that's how we're going to move with the technology. Exercise caution, and definitely no doubt that human intelligence is above everything. We have the ability to destroy anything, we have the ability to create anything. So I would like to now open the floor for questions if our students may have any.
So, since we were discussing on the topic of accountability, let's say if a client has approached regarding a dispute, then how should we address confidentiality concerns when a client data is processed through AI tools for contract drafting or contract review?
Okay, so see, confidentiality has always been there. I mean, there would be an NDA which is signed. There will be a confidentiality clause in the contract. When we are dealing with the lawyers, they are professionally bound to maintain the client-attorney privilege and the client-attorney confidentiality. But let me extend your question to another level where these are new discussions that's happening on the point of data. Right? So when you talk about confidentiality, it should also include the data confidentiality. And that's where the consent manager has come into the picture, So between data subject and data fiduciary, there is a technology, a tool which is called consent manager, right? So data subject, data fiduciary, in between there is a consent manager. Everything will be routed via that consent manager. And there are guidelines who can be a consent manager. So confidentiality is something which has to be there. I mean, people will have to manage it. There has to be clauses related to that from a legal point of view. From a practical point of view, a lot of organizations have their systems and places. Information security systems are tightened. The computer systems are tightened. And therefore, technology is there to tighten that. Wrong leakages or a leakage of confidential data is absolutely not there.
I think that's where also negotiating your contracts with the tools that you're going to use, that's very critical. The assumption as law firms, because there is attorney-client privilege, everything that's coming to you is confidential, right? If you're going to put it in your tools and use it for whatever you use it for, and the model's going to learn off it. If you've not negotiated well in terms of what the end use of the information you're putting into your models is, you're spelling trouble for yourself. I saw something, I haven't verified it, but I think in the US now they're saying that if you put something out into a ChatGPT or an agentic model, right, it can fall out of privilege and subject to discovery and litigations. So we have to be very careful as to what we're putting in any of these tools.
Just to add, I'll give you 2-3 examples. Many of the organizations, including our organizations, employees are not prohibited from the usage of GenAI. So they say that, okay, use GenAI, but then there is in between there is a filter. And they say that you reach to generative AI tools through this filter, which is the organizational filter. And therefore, many of the, you just can't put your confidential documents into the cloud and then So they are saying that use it through this filter, and many organizations are doing it. So that filter is in between, and therefore employees can access to GenAI through this filter, and this filter can filter if you are sending your confidential documents for generating some questions or answers.
Any further questions? Priyanka.
The question is, if you are using AI tools and you feed some data to train it or get an output, whether that data can be used by some other organization. So there are, whenever such AIs are deployed with an organization, Lucio, you have Harvey, Legora, so the contracts are drafted in that sense that everything stays in that enterprise. It cannot go beyond the law firm or an organization for which it is being put for use. So that is one aspect. Secondly, you will also have to see how much confidential data can you put in. You will have to use, you will have to analyze that this is the only thing that I should put, and that's where human intelligence kicks in. So that's. There is. No, there is because so the contract is not with the AI. AI has no legal personality. That's a debate for a second, sometime later. It has no personality. That contract is with the developer. That when you are putting that module in our organization, the large legal modules as we tell, it will be used only for a particular organization. It will not be used for some other purposes. Even that training, the data that it has absorbed will not go out of the organization. It's like a cloud-based system, if I were to say, on a layman term.
And the extension of that is also in your personal lives. When you use ChatGPT and cloud, maybe, you can just go into your settings and turn off, the ability for the model to train or your information to be shared onwards. So that setting in the personal capacity also exists. An extension of that is what organizations, laymanishly put, are what we use.
No, but this Azure, which is used by Microsoft, all the data are on the cloud, right? And Microsoft has a huge, long, multiple pages clauses on the security of these data on the cloud. Because if that gets leaked, it will collapse, the system will collapse. So there are very, very strong clauses on the protection of your confidential information, confidential data, when you are sending it through the cloud. And that is where the trust factor comes, because people will not go to any other cloud-based service provider, but people go to Microsoft because there is an element of trust. So that those clauses are already built in, and there are a lot of Microsoft organizations like Microsoft have a huge clauses because the liability is huge. Right?
Thank you so much, sir. On that note, we would conclude our panel discussion for today. And I would like to thank our distinguished panelists for the same, so bringing in so many insights into this session, and also the audience for being so engaged. So thank you so much, everybody.
Many thanks to the panelists for bringing such depth, clarity to discussion on the regulatory and practical challenges shaping modern contractual obligations. Your perspective on the intersection of technology and legal framework have highlighted a delicate balance between enabling innovation and ensuring robust ethical and legal safeguards. Today's exchange have clearly underscored that while artificial intelligence enhances efficiency, it also calls for a careful re-examination and evolution of established legal principles to address emerging complexities. As we come to the close of our intellectually enriching session, I would like to request Professor Dr. Sujata Bali, Dean School of Law, to kindly present the vote of thanks.
Distinguished speakers, esteemed colleagues, dear students, participants, and guests. On behalf of School of Law, ILM University, Gurugram, I extend our heartfelt gratitude for making our first law roundtable on navigating commercial contracts in the age of AI and automation a resounding success. Your insightful discussions have enriched our understanding and sparked vital conversations which we intend to continue in our academic pursuits ahead. A special thanks to our esteemed panelists, Mr. Amar Sundaram, Ms. Simran Barar Kapoor, Mr. Aditya Vikram Jalan, Ms. Anshum Singh, and Mr. Madhav, as well as Mr. Kindra for their presence today. Our special thanks are also due to the Center of Commercial Law and Corporate Governance core faculty, Dr. Asta Mehta, Dr. Ratrika Deb, Dr. Archana Sehrawat, Dr. Monica Yadav, Dr. Monica Bhatia, Ms. Ekta Yadav, and students who organized this event with such dedication. Your efforts behind the scenes are invaluable. And to all attendees, your active engagement truly made the discussion come alive in this present AI era. Going forward, we shall produce a position paper on the same theme and share with you all. Universities and academics have a great responsibility to assimilate, disseminate, and create knowledge. In partnership with legal practitioners today at ILM School of Law, Gurugram, we hope that we have done our bit in the same direction. Thank you once again for joining us in this conversation today. Stay curious to learn and stay blessed. Thank you.
May I now request everyone present to kindly rise for the national anthem.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
I request all the esteemed guests and faculty members to kindly join us up for a group photograph.